Good morning. Before we start, I just wanted to check, Miss Rains, are you going to be on camera this morning?
No, I couldn't get it to work. Sorry, but I am on audio. I mean on
Oh,
yes, on audio.
okay, no worries. We will uh, make sure to give you time to talk and we can hear you, so that should be just fine.
Okay, thank you.
Okay, no problem. Well, welcome to the Office of Tax Appeals. We're ready to begin with the appeal of Nouri. The OTA case number is 220911497. The oral hearing will be live streamed and is being live streamed right now. Um, Also present today is a stenographer, Ms. Alonso, who is reporting this hearing verbatim. To ensure we have an accurate record, we ask that everyone speaks one at a time and does not speak over each other. Also, please speak clearly and loudly. When needed, Ms. Alonso will stop the hearing process and ask for clarification. After the hearing, Ms. Alonso will produce the official hearing transcript, which will be available on the Office of Tax Appeals website. The Office of Tax Appeals is an independent and neutral agency. It is not a tax court. All three judges are co-equal decision makers, and we can all ask questions at any time. Uh, I'd like to offer a few reminders to help the process run as smoothly as possible. First, as noted a moment ago, this hearing is live streamed, so anything that you say will be shared to YouTube. Keep that in mind, and please don't share any sensitive documents on the screen. When you are speaking, please make sure that your microphone is not muted. Please make sure that make sure that your microphone is not muted so that we can all hear you. And on the other side of the coin, please make sure that when you're not speaking, your microphone is muted. That helps us avoid feedback loops and also any other background noises that may occur. And so with that said, are there any questions before we go on the record? Okay, I see a lot of heads shaking no. And so we will go on the record if Ms. Alonso is ready. Okay. We're opening the record in the appeal of Nouri. The OTA case number is 220911497. This matter is being held before the Office of Tax Appeals. Today's date is August 22nd, 2024, and the time is 10:50 a.m. This hearing is being convened electronically. Today's hearing is being heard by a panel of 3 administrative law judges. My name is Keith Long, and I will be the lead administrative law judge. Judge Sarah Hosey and Judge Josh Lambert are the other members of this tax appeals panel. All 3 judges will meet after the hearing and produce a written decision as equal participants. Although the lead judge will conduct the hearing, any judge on this panel may ask questions or otherwise participate to ensure that we have all the information needed to decide this appeal. As a reminder, the Office of Tax Appeals is not a tax court. It is an independent appeals body. The panel does not engage in ex parte communications with either party. OTA will issue an opinion based on the party's arguments, the admitted evidence, and the relevant law. For the record, will the parties please state their names and who they represent, starting with the representatives for the Franchise Tax Board?
Good morning. This is Andrea Watkins with the Franchise Tax Board.
And I'm Cynthia Kent, also with the Franchise Tax Board. Good morning.
Morning. And for the appellant?
Yes, I'm Frank Gomez. I'm with CBIS Data Tax.
And Ms. Rains, are you there? You're muted.
Yes, good morning. This is Eileen Rains from CBIS Data Tax, and we are representing Hassan and Mariam Nouri.
Thank you. There's one issue in this appeal, and it is whether FTV's proposed assessment, which is based on a final federal audit determination, should be reduced. There are several exhibits that were received from FTB. They consist of exhibits A through L. At the pre-hearing conference, appellant had no objections to exhibits A, B, C, F, G, and H. Can appellant please confirm that there are no objections to those exhibits?
Yeah, there's no objection.
Thank you. Additionally, appellant requested copies of exhibits D, E, I, and J. Did appellant receive those exhibits, and are there any objections?
Yes, we received them and there's no objections.
Thank you. Finally, after the pre-hearing conference, FTB provided Exhibit K, updated 2017 federal account transcript, and Exhibit L, 2017 California wages and withholding details. Does appellant have any objections to exhibits K and L?
No objections.
Okay, thank you. FTB exhibits A through L are admitted without objection. After the pre-hearing at the pre-hearing conference, appellant indicated that they may be providing exhibits, and there may be a witness. No exhibits or witnesses were identified for this hearing. I anticipate that to be correct. Is that correct, Mr. Gomez?
There was no witnesses, but we did send in simply the W-2s that were added. I guess they're also on the wage and income transcript. So that's
Okay, let me just double check. Okay, I do not have those. When were those sent? Were those sent with the opening brief, maybe? Or were those sent after the pre-hearing conference? Oh, Mr. Gomez, you're muted.
it was sent on the deadline for the evidence to the evidence email.
Okay. Was it sent through the portal or sent via fax or mail?
It was sent through an email to whoever, I don't remember exactly the email, but it did start with evidence at whatever it was to the court.
Okay, well then,
Judge Long, FTB did receive a copy of those W-2s.
okay. I am going to pause and go off the record and figure that out. Uh, give me 5 minutes, please. And so I'm going to turn off my camera and mute my microphone and ask that everyone else do the same as well. And we will return here at 11 o'clock. Thank you. Is everyone ready?
Yes.
Yes.
Ms. Alonso, are you ready? All right, my co-panelists, are you ready to go? My apologies. We do have them. There seemed to be a minor labeling issue in our system, but I do have the exhibits, and it appears that they were timely. Franchise Tax Board, do you have any objections to these exhibits?
No objections.
Okay, then they are admitted as Appellant Exhibit 1. Um, Sorry, we're going to go back on the record. Having heard no objections from Franchise Tax Board, appellant's exhibits are admitted as Exhibit 1. Okay, now, at the pre-hearing conference, FTB asked whether appellant agreed that appellant H. Nouri was the sole shareholder of Sahar. FTB also asked whether appellant agreed that the IRS assessed additional tax and had not revised its determination. Appellant did not provide an answer at the pre-hearing conference. Does appellant have answers to these questions now?
Yes. We do agree that,
Mr. Gomez?
Yeah.
I'm sorry, real quickly, you're coming in a little staticky and it's a little hard to understand you. If you could maybe speak a little closer to your microphone.
okay. Yes, we do agree that Mr. Nouri is the only owner on the company. And we did see the additional assessment on the IRS transcript, which has not changed.
Thank you. Okay, then those items are considered not in dispute. Today's hearing is expected to go for approximately 45 minutes with the taxpayer's opening presentation lasting approximately 30 minutes. Mr. Gomez, Ms. Rains, you may start when you are ready.
Yeah. So the issue was surrounding additional unreported income. And initially, I spoke with the taxpayer who said that these second W-2 was issued an error, but the payroll company has not made any corrections, and I can see the payroll taxes were paid. So if we are accounting for the additional income, we would account also for the additional withholding that the W-2s do state. And based on the W-2s, the withholding does exceed the amount of tax that's stated the new balance FTB posted in the thing the collection is based on. Additionally, the taxpayer did make a $5,800 estimated payment for that year as well. So considering those payments, there should be a refund for tax year 2017. And I do understand the refund would be less than what was on the original tax return. And I see that the amount that is requested as a balance is the difference between those refunds. And that would make sense if the client or the taxpayer had received a refund check, but they did not actually get payment. And it was requested to be rolled over into the estimated payments for 2018. And so if that was true, it would have been making a difference or would come into play in the tax year of 2018. So if that higher amount was applied, potentially it could have a balance due for 2018. But there's no, nothing was presented on if that amount was applied, that the higher amount was applied, or if any changes were made after that by the taxpayer or the FTB, simply that 2017 would show there was no balance due. And then even if it did create a balance due for 2018, that would be due starting April 15 of 2019 instead of April 15 of 2018, as stated on the assessment note. So as far as I can see, there's not a balance for 2017, potentially for 2018, but has not been presented. So we would say that they did not have anything due for 2017.
Thank you. I just wanted to clarify a few things real quickly before I turn it over to our co-panelists. First, so to be clear here, are you now conceding to the additional income, but arguing that he's entitled to a refund because the withholding and estimated tax payments exceed the liability asserted by FTB?
Correct.
Okay. And I'm sorry, for me, I just wanted to make sure that I heard you correctly. The asserted estimated payments were $5,800. Is that correct?
Yeah, it was 500 or $5,803.
Okay. Okay. Thank you. And do my co-panelists have any questions? Judge Lambert, Judge Hosey, do you have any questions? Starting with Judge Hosey.
No questions from me. Thank you.
Thank you. And Judge Lambert, do you have any questions?
This is Judge Lambert. I don't have any questions. Thanks.
Thank you. Mr. Gomez, does that conclude your presentation?
Yes, thank you.
Okay. Well then at this time, I would like to turn it over to Franchise Tax Board to make their presentation. And you may begin when ready.
Thank you. Good morning. My name is Andrea Watkins, and I, along with my co-counsel, Cynthia Kent, represent the Franchise Tax Board, or FTB. The issue on appeal is whether, for the 2017 tax year, the appellants have established error in FTB's proposed assessment of additional tax, which is based on federal action. FTB accepted the appellant's timely filed 2017 California return, in which appellants reported, in pertinent part, $312,000 of wage income. However, FTB subsequently received information from the IRS indicating that it had assessed additional tax based on unreported income consisting of $138,000 of wage income, $216 of dividend income, and $93 of annuity income. FTB followed federal action and issued a proposed assessment of additional tax based on the same unreported income. Appellants argue that the bulk of the unreported income, $138,000 of wage income, was misreported by Mr. Nouri's employer's payroll company, and that he in fact did not receive these wages. Mr. Nouri is the president and sole shareholder of Sahar Inc., his employer, and although he argues that he did not receive these wages, there was $7,841.39 of California tax withheld from this income, in addition to federal income tax withholding. FTB requested and received wage and withholding details from the Employment Development Department, shown in FTB's Exhibit L, which show that Mr. Nouri's employer reported a total of $450,000 of wage income paid to him during 2017, and California tax, which was withheld from that wage income. The 2017 Federal Wage and Income Transcript, which is FTB's Exhibit D, shows two W-2s issued to Mr. Nouri, one for $138,000 and one for $312,000, totaling $450,000. And both W-2s show federal tax withholding. Further, although the appellants claim to have filed an amended return with the IRS, a recent federal account transcript does not show that the IRS has accepted an amended return or abated any tax. Based on the appellant's presentation today, yes, it is true that there was additional tax withholding from the unreported income. And that tax withholding was actually credited to the appellants. If you look at FTB's notice of proposed assessment, let me see what exhibit that is. That would
It's
be
Exhibit F.
Exhibit F, yeah. You'll see that the additional withholding credit, $7,841 and 39 cents, was credited to appellant in the calculation of the additional tax. And then appellants also mentioned that they had estimated an estimated tax payment that they requested to be applied to tax year 2018. And that, in fact, was applied to tax year 2018. If you look at FTB's Exhibit B, which is the 2017 tax year detail, it does show that payment applied to tax year 2018. So the NPA, the Notice of Proposed Assessment, does include that additional withholding credit, and it also does factor in the estimate payments. Appellants have not proven error in the proposed assessment. Therefore, it is presumed correct, and FTB respectfully requests that its position be sustained. And I'm happy to answer any questions from the panel.
Thank you. Judge Hosey, do you have any questions?
This is Judge Hosey. No questions from me. Thank you.
Okay. And Judge Lambert, do you have any questions?
This is this is Judge Lambert. I just wanted to confirm how many FTV, what was the amount of payments that appellant made that were applied to 2017?
Let me pull that up. So $16,589 was transferred to 2018.
Okay. Okay, thanks. I think I see how it works. I don't have any more questions. Thanks.
Okay, thank you. We are going to turn to our closing arguments and allow appellant time to make their final statements. You have 5 minutes, Mr. Gomez and Ms. Rains, and you may begin when ready.
Yeah, so our closing statements are actually that I know the state said they gave credit and applied the estimated payments to 2018, but what we're saying is that the withholdings from the W-2, which were totaling 36,342, along with the 5,803 estimated payments, totals $9,831 more than what they are saying the revised total balance due was for that year. So even with their numbers, it would result in a refund for that year. I understand that normally if they got a refund, the taxpayer received a refund, you could collect the difference between the smaller refund and the larger refund, but they did not actually receive a check for that. It was requested to be forward that refund forward to 2018. I don't see that it's forward to 2018. And even if it was, the balance due that might be created if that number was supposed to be smaller and they did credit a higher number, it would create a balance due for 2018, not 2017. So if you account for the payments, there should be a refund for 2017, not a balance due. And if there was a smaller refund, it would affect 2018. So if you were going to collect something, it would be for 2018, not 2017. And then the start time where interest would again be a year later than the time.
Thank you. I just want to make sure that I'm clear with respect to your argument here. I am looking at, right now, I'm looking at FTB Exhibit B. I have that on April 15th, 2018. There is a transfer to the 2018 account of $16,589. Are you saying that then there should have been, how much are you saying should have been transferred?
I'm saying on the two W-2s that we submitted, there was withholding on one of them for 28,501.
Uh-huh.
And the second one, which was that additional income, $7,841. So that would total $36,342. According to FTB, the revised balance due was $32,314. So that means there's a refund there. In addition, there was an estimated payment made of $5,803, which would increase the refund. Now, I understand on the original return, the refund was higher than what this revised number would be, but it's still a refund. So there would be nothing due in 2017. And they did not receive that refund check from 2017. It was rolled over to 2018. So if there is a difference in what that number should be, if it's smaller and they applied the higher number, then yes, it could create the balance due in 2018, but no one has presented anything about 2018 right now. So for 2017, it should be a refund. In 2018, possibly there is a balance due, but there's nothing showing.
Okay, thank you. Before we close our hearing today, I just want to check with my co-panelists. Judge Hosey, do you have any final questions?
No questions from me. Thank you both for your presentations.
And Judge Lambert, do you have any final questions?
This is Judge Lambert. I don't have any final questions. Thanks.
Thank you. Okay, thank you, everyone. We're ready to conclude this hearing. This case is submitted on Thursday, August 22nd, 2024. The record is now closed. I want to thank everyone for making their presentations today. The judges will meet and decide your case later on, and will send you a written opinion of our decision within 100 days after the record is closed. Today's hearing in the appeal of Nouri is now adjourned. This concludes today's hearings.